Yes, Banafa.
Okay, my question is with regards to shares, whether a merger can cause shares to be deemed,
Are you
or
okay?
if not, like.
Are you okay?
Yes, it's a question. I'm trying to rephrase. That's why.
You're doing probate, my friend. Can you be serious? You're doing probate.
Yes,
Probate
it's a
class.
probate question. And
You cannot
yes, it's a
ask
probate
mergers
question.
and
And
mergers is not a probate question. How is
in this
mergers not a
question, there
probate
was
question?
somebody. It's a 2024 question, April, whereby somebody had bequeathed shares.
What is your
Now,
question?
that somebody had bequeathed some shares as a gift to somebody, but then the shares in that company, okay, eventually there was a merger between the company with another company, and a new company had been formed. So the question is now, did the merger cause the shares to be redeemed or not?
Did they?
Did the merger have an effect with regards to the shares being redeemed or not when you talk of redemption?
You tell me. You're the one who's read the question. I've not read it. What happened to the shares?
We were just told that there was that merger, and based on that merger, now would the gift still pass to that intended person or not? That was the question.
And who
So in
was
other
told
words, I
you?
was trying
Who
to
was
ask you.
mentioned? Did the question mention redemption? Did the
No, it's
question
something we
mention
spoke about in
redemption?
our discussion.
You can't hear me. I'm asking, did the question mention redemption?
No, it didn't.
Then why are you mentioning redemption?
It was mentioned during one of the classes discussions, so I thought maybe I would bring it up and seek a clarification.
That is, you mentioned redemption. I'm wondering where is redemption coming from in that instance. Anyway, but I will need to, that is not a direct question because I don't have the facts of the question. I don't have the question. We'll look at that question. Of course, that is the paper we'll start with when you start doing past papers in the next two classes. So just give me 1 second. So Banafa will do that question. Don't worry. I'll need to look at it and read it myself, and then we can have a discussion about it. It's the first paper that we'll do, the 2024 paper. All right. So if you have another question, put up your hand. Give me 1 second, please. All right, so is there any other question? I've seen a lot of back and forth in the group in terms of certain things. Is somebody going to ask that question, or you guys are okay. I thought maybe we could start from there. I thought maybe we could start from there. So is there anybody going to ask the question? Yes, Kevin, we start with you so that we make things clear and move on.
Yeah, good evening, Mwalimu in class. So regarding that discourse, I had asked a question in the chat.
Which discourse is that?
I'm coming to that. There was a comment to the effect that concubines are not entitled to a share under intestacy. And somebody mentioned that they are actually covered under Section 3. Is it 3.5 of the Law of Succession Act, by which refers to women, to wives who are married to men who are under a system of polygamy. I'm trying to paraphrase the section.
What is your question? Go to the question, please.
Yes. So the question I had asked myself, I don't know about others. You had commented that that section does not deal with the presumption of marriage, nor concubines. And I asked you, what women are those in that section?
You're not asking me a question, Krieger. What is your question? You said a lot of things about who is a concubine in the first place. Who is this person you're calling a concubine?
Concubine is not a legal term, but
use a legal term, please.
Okay, these are women who are not lawfully wedded, but they are in some form of.
Why mentioning a wedding? Wedding is does wedding make a marriage?
They are not legally married to men, but they have some form of relationship. We can call them pangwakando.
So what is the question?
The question is, okay, please explain what these women are in Section 3. Is it Section 3.5?
Kiriga, you are not asking a question. What do you mean explain who these women are? What is your confusion? What is the question, really? I'm not getting your question. You're asking me to explain who a concubine is. That's what you're asking.
Give me 2 seconds. I read Section 3 so that I can ask the question. Just a few seconds. Thank you.
Somebody else with a question. As Kiriga is asking.
Okay, Mwalimu, I found it. Section 3.5. Notwithstanding the provisions of any other written law.
I know that section.
Yes.
I know what. Ask the question. Don't read it.
The question is, who are these women if they are not concubines?
Which women? Jesus. Which women are you making reference to?
Section 3.5 is describing a woman married under a system of law which permits polygamy, whether her husband has contracted.
Is a concubine married under a system that permits polygamy? Is this person you're calling a concubine married? Let's start there. Section 3.5 is saying a woman married under a system that permits polygamy. Is this woman you're calling a concubine? Is she married under any system?
No, she's not married under any system.
So what is the question? Now lead me straight to your question.
One, the husband in this section is someone who has contracted a previous or subsequent monogamous marriage, which would mean the woman is married to a man in a monogamous union, which does not allow contracting a second marriage. So the question is, that woman cannot be said to be legally married to the husband. So that
Who is that? Can somebody mute your microphone?
sorry. So Mwalimu, there's a man who is married, who has contracted a monogamous marriage. By Marriage Act, they cannot enter into another marriage during the subsistence of that marriage. That man has married a woman under a system of law which permits polygamy. And my point in the group was that because that marriage is void, we cannot speak of that marriage as it is equivalent to a concubine relationship with a man. So
I'm asking
please
you,
describe.
is a concubine married? Who is the woman under section 3.5? Let's start there. Who is that woman?
That is what you're asking, Mwalimu.
What is section 3.5 saying?
Notwithstanding the provisions of any other written law, a woman married under a system of law which permits polygamy.
So who is this woman? This woman is what? What is the first feature of this woman?
She's married to a man under a system of law which permits polygamy, which would be either.
Just stop there. And who is a concubine? What is the first feature of a concubine in your own understanding?
A concubine is a relationship that defies, it has no status in a marriage.
So is a concubine married under a system that permits polygamy?
No.
So if a concubine is not married and the woman under section 3.5 is married, on what basis do you think they're the same people?
Mwalimu, permit me to ask you a question.
Ask.
If a man is in a monogamous marriage and they contract a second marriage, can you say that they are rightly married to the second woman, even if they underwent through all the formalities?
They're married. That is what it is. They're married.
To the second spouse?
They are married. What is marriage? What is marriage? If it is a traditional marriage, you go and pay dowry, you do the traditional things in Kikuyu land, Luo land, Kisi, Nandi, you do those traditional things. That is marriage. So they're married. The next question is the validity of that marriage. The marriage is existing, but the question is the validity of that marriage. Is it a valid marriage? So they are married. It is only that we cannot give validity to that marriage just because the man lacks capacity. That is the woman under section 3.5. She is married. She's a married woman. It is only that she's married to a man that is already married under a monogamous system. This person that you're calling a concubine is not married to anyone. Are they married? Have they celebrated any form of marriage? This concubine, quote unquote, have they celebrated any form of marriage, Iriga?
No. They would be called a wife and not a concubine if they were married.
So then why are you equating the two of them as the same? Why are you saying they're the same?
Okay. My understanding was that a void marriage is not a marriage in the first place.
No,
And
it is a
because
marriage. It is a void marriage. It's a void marriage. But the other one is not a marriage at all. Okay. The second instance, they have not they have been married. Anyway, let me explain this point so that it's clear to everybody. Let me explain this point and make sure that it is clear. Okay. Let us make sure that all this is clear. Now, when you look at section 3.5, because there are few things that people are confusing. Guys, the first person you're confusing is the lady under section 3.5. The second person you're confusing is a cohabitee. And the third person you're confusing is now the person you're calling a concubine. A concubine is a girlfriend. There's nowhere in law that the law recognizes a girlfriend. Whether that man was maintaining you, paying your rent, paying your hospital bill, paying you everything, you do not qualify as a beneficiary unless you are taken in as a child, not as a concubine. The question of maintenance and being maintained by the deceased person only survives on children that were taken in. So if the deceased person was your boyfriend who is married and was paying your rent somewhere, okay, was paying your rent, was paying your bills, was paying everything literally, then if they die, you can't inherit from their estate. Why? Because you are not their children. Even though they were maintaining you, you are not their children that they took in. Okay? So remember, for you to inherit from the estate of the deceased person, also where there is no will, then you are either their wives, and we've discussed the three categories of wives. The first wife is a wife that is married under the Marriage Act. The second person that is a wife is the common law wife. And this is the common law wife. This is the woman that is married subject to the provisions of Otensawa Wanjiku versus public trustee, the common law wife, the cohabitee, the lady that has cohabited with this person for a long time until there's a marriage that has been that has been presumed. Okay, that is the common law wife. That is the common law wife. And then after that, we have somebody called now the woman under section 3.5. That is the wife for purposes of succession. The wife for purposes of succession. That is the third person that we are calling the wife. So you are either in the category of the wives. For you to be a wife, there are only three things you can prove. You are married under you have a marriage under the Marriage Act, you're the common law wife, or you are the woman under section 3.5. Now, the woman under section 3.5 is actually married. It is only that they are married, they meet the qualifications of the marriage under the common law. Okay, so this person went to your home, they were already married, maybe you didn't know they were married, they went to your home, they paid your dowry, they paid everything, they passed all the rights depending on which tribe they're coming from until they married you. But only that, at the time they were doing all that, they were already married under a system that does not permit polygamy. They're already married under a monogamous marriage. So there are two existing marriages here. One is under polygamy, one is under monogamy. So in this instance, the woman under section 3.5 is the lady that is married under the system that permits polygamy. And because of the element of capacity to get married, then this woman will not be protected, and she will be called now a woman under section 3.5. Are you together? That is exactly what we're saying. That is exactly what I'm saying. So this woman is a woman under section. She's being given a favor because she was actually married. She's not a concubine. Okay, she's actually married. Only that she is married at a time when the husband is already married. and that woman is the woman under Section 3.5. The next person is now the child. For you to inherit, if you don't meet the qualifications of the woman under Section 3.5 or Tensai Wanjiku Yai versus public trustee and the Marriage Act, then you are either the child. So for you to become the child again, you are given birth to by the deceased person, you are legally adopted by the deceased person, and you are a child that were taken in by the deceased person as their child, not as their girlfriend, as their child, and they maintained you prior to the death. So you fit within those three categories. If you don't fit again in the definition of a child, then you now become under section 29B, which is either you are the parent of that deceased person, you are the mother or the father, the deceased person's parent, you are the brother, you are the sister, the stepsister, the stepbrother, half sisters, half brothers, and the relatives up to the 6th degree of consanguinity. Those are the only people that can inherit. So if we don't have the wife, we go to the child. If we don't have the child, we go to the parents. If we don't have the parents, we go to the brothers and sisters. If we don't have the brothers and sisters, then we go to the grandparents or all the relatives up to the 6th generation. Okay? Now, if we don't have the relatives up to the 6th generation, we cannot now call the girlfriend. No, we take that entire property to the government. The government will take the entire estate because we don't have any relative up to the 6th generation. So you being a girlfriend, being maintained by this guy that died, you can't claim anything unless you are claiming that you were married. Okay, unless you're claiming that you're married. So if you are married, then you can claim from the Marriage Act by saying, yes, I was the one who was married first. So if you have evidence that you were married first before they married their wife, the one they married, whichever system, then you fit in there. Or you are saying that you are cohabitee, you have cohabited with this person for a long time, and meet the requirements Tensai Wanjiku versus public trustee, well and good. Or you are claiming that you are now the woman under Section 3.5, well and good. But other than that, you can't inherit from that estate just because you're a concubine. There's nothing defined in law as a concubine. The entire law of succession, there is nowhere in law where a friend, whether a boyfriend or a girlfriend, can inherit from the estate of the deceased person. If the deceased person wanted you to inherit something from the estate, they would make a will and include you as a beneficiary in that will. If they don't do that, you cannot benefit. Are you together? And if you go to the rules of intestacy, who is supposed to inherit? The surviving spouse and the children. If they're not spouse and they're not child, then we go to the parents. If the parents are not there, then we go to the list of relatives. If the relatives are not there, then the government will step in and claim the property. I hope I've explained that point very well.
Mwalimu is quite clear. A question still on 3.5. Why is it particular that the woman must be married under a system of law which permits polygamy? And what would be...
She's the one being protected. She's the one being protected because under the system that does not, under the monogamous system, that marriage ranks in priority over customary marriage. The statutory marriage and the church marriage ranks in priority over the customary marriage. And therefore, if there's evidence that you are married under the customs, then, because remember, when it comes to the statutory marriage, there are requirements that must be met. There are statutory requirements that must be met, the same as the church marriage. Okay? Now, in that instance, it is only the person that is married under the customary law that will be given the protection. So either you are married first or you're married last. So that is the reason why we protect that lady under Section 3.5.
So, supposing she was married under a monogamous union, let's say a civil marriage, which would be fraudulent because the man is already married, would she be protected by this section?
Answer yourself now. What is the section say? What is the section saying?
Okay, the section is particular that the system of marriage has to be polygamous.
So what is your question now? If the section is clear.
What I'm driving at is, why would the law discriminate against two types of void marriages, Walimu? Because if she was married under...
That is what it is. And I've just explained that the monogamous marriages will rank in priority over, because there are statutory requirements that must be filed for that marriage to be valid. You have to sign an affidavit, for instance, if it is a statutory marriage, you know. So, and of course, these marriages are published. These marriages are published. So therefore, they have priority over customary marriages. And therefore, it is the customary marriage that we protect. Number two, there are high chances of having a customary marriage without knowing the existence of other marriages. There are a lot of chances that men will use that phrase, okay, will use customary marriages to deceive women. You know, people will use customary marriages to deceive women. And that is the reason why we had Section 3.5. That is the exact mischief that 3.5 was coming to cure. The mischief of men using customary marriages. They know they are already married under church, and they know very well that they can't marry again under church, but they don't disclose that to these women. They just proceed and pretend that they're marrying them under customary law so that they satisfy the question of marriage. Now, because of that, these women were left stranded. Okay, it is not their fault. They were left stranded, and that is why the law came in and took them in and said, fine, this is the protection. When it comes to customary marriages and statutory marriages, you can't get the protection. Why? Before you get married under church, these are marriages that are already registered. You should even do a search in the register of marriages to confirm whether this husband of yours is already married. Customary marriages, there's no way you can get a search to confirm the existence of this marriage. So the law requires that before you are married under the AG's office, before somebody takes you to the AG's office, I mean, you can do a search and confirm whether they're already married, you know, so you can't get a second marriage. Remember that you can't get a second marriage under church, which that would be a legality in the instance. So definitely, that is the reason why we are protecting and this is a historical provision. 3.5 is a historical provision, and I've given you the cases of Riogola, Riruenji, Ruben Ziokamutua. You know those cases, and that is the same reason why the parliament now amended Section 3.5 to protect these women that were being left stranded after this man they've lived with for a long time, given birth to children, married them actually when they thought they were married, kumbe they're not married. So that is why the law is protecting them. When it comes to these other marriages, they are not given any protection. Are we on the same page?
Asante sana. Imeingia.
Yes, so don't confuse the woman under Section 3.5 and a cohabitee. Section 3.5 has nothing to do with cohabitation, guys. Section 3.5 has nothing to do with cohabitation. It has nothing to do with cohabitees. Section 3.5 is not about cohabitation. It talks about marriages. You have been married. A cohabitee is not married. Okay? A cohabitee is not married. So we just presume the existence of that fact. 3.5, there was dowry paid. There was a chicken that was slaughtered at your maternal home, whichever the custom you come from, you know. So there's evidence of marriage when it comes to 3.5. When it comes to the question of cohabitation, there's no evidence of marriage. That's why we are presuming it. So don't confuse those two things. And a cohabitee will always have to prove the factors in Otensawa and Jikuyawe, which of course the government, the Supreme Court has reinforced in 2021 by making it clear that yes, cohabitation is still existing, cohabitation is very valid, but subject to the factors that the Supreme Court listed. So don't confuse those three people. Those three people are very different. Those three people are very different. 3.5 is not cohabitation. Cohabitees are not under 3.5. So are we together, guys? So yes, this man could have lived with you for 5 years, taken care of you, provided for you, maintained you. But so long as they didn't marry you, you can't fall under section 3.5. The best you can try to do is cohabitation, which you can prove cohabitation. But if they were married, you can't prove cohabitation. Remember that if this man was married, you can't prove cohabitation. And that needs to be very clear. Guys, when the man was already married, before you started cohabiting, they cannot be cohabitation. They can never be cohabitation, because cohabitation is an actual legal marriage. Cohabitation give rise to a legal marriage. Are you together? Section 3.5 does not give rise to a legal marriage. That woman is only called a woman for purposes of marriage. So, a wife for purposes of succession. So it is only for succession. But a cohabitee transcends even after succession. A cohabitee is a wife for all purposes and intents. Even 100 years after the death of the deceased person, the cohabitee will still be their wife. But the woman under section 3.5 is really not a wife because of lack of capacity, and therefore they cannot become wives after succession is done. So remember, you can't cohabit with another person's husband. Hiyo injili nafaa niseme vizuri. Hiyo injili nafaa niseme vizuri kabisa. Then kama inaingia. You cannot cohabit with another person's husband. You can only prove cohabitation if this man is actually single. Guys, you can't suggest cohabitation if the man is married. Okay, unless they're married under polygamy. But if they're married under a system that is church or statute, you can't prove cohabitation. Are you together? All right. Guys? Okay. Any question? Zaweria?
So, Mwalimu, what normally happens to the cohabitees? Do
What do
they
you mean?
normally get a share in the estate, or
What do you mean? Zaweria, your microphone is muted and you're asking a question. Can you unmute and ask?
so? Because you said you cannot cohabit with a married man. So I'm making reference to a situation where there was a cohabitee and now there was the wife. So in the event that the man dies, what normally happens to the cohabitee? Does she get a share in the estate of the deceased?
But she's a wife. What do you mean? She's a wife. Is she not? She's the wife of the
Okay.
deceased person. That's what I've said, Zaweria. For instance, right now, if I'm already married, okay? If I'm already married right now and I have an affair with you, you can't prove cohabitation because I was already married. And therefore, what happens to you when I die is that you can't get anything. You can't get anything through cohabitation. You can't get anything, okay? But if I'm a single man and I have an affair with you for 7 years or 10 years, we have a kid, or 15 years, we have 2 children, and we have properties together, and I die, then you as Zaweria, you will go to court and tell the court like, hey, somebody mute your microphone, please. Mute your microphone, please, before I call you out. Mwenga Mora, your microphone is always very much on. Okay. So, like I'm saying, if I'm already, if I'm a single guy and we have been cohabiting for 7 years or 10 years or 20 years without actually marrying you officially, then if I die, then you become my spouse, you become my widow as a result of presumption of marriage. And therefore, if you successfully prove that you are the cohabitee, then you are a wife, just like the wife under church. So you are still the widow, as if I had married you in church or as if I had married you in statute. So cohabitees don't exist alongside other wives. Where there's a first wife, there's no cohabitee. I don't know whether tunaelewana. Cohabitees are independent people. They don't exist alongside other wives. It means if this man had a first wife in the village, you can't prove cohabitation in that instance. Okay, you can't prove cohabitation in that instance. If this man had a first wife in the village, you can't prove cohabitation. You can only prove cohabitation if this man was actually single. That is when you can claim to be his wife. Okay, so in the instance where they had a wife in the village, which they had married, and then they came to you and also lived with you for years and years and years, then if they didn't marry you under customary law, or if they did marry you under customary law, then you prove 3-5. Okay? But if they were married in the village, they came to you, they just live with you without marrying you anyway, you are just a girlfriend. Unfortunately, you can't benefit from that estate. You don't have status in that estate. So cohabitees are not second wives. Cohabitees are not third wives. Cohabitees are first wives and only first wives. Unaelewana?
Yes, understood. Thank you.
Okay, Okiega?
Yes, Malimu, good evening. And in the instance where a single person cohabits with more than one woman, what happens in the circumstance?
What do you mean?
At the same time, this man has got 3 ladies whom he has cohabited with for enough time, and all of them have actually met the parameters of being referred to as a cohabitee. Now, at the point when this guy dies, what really happens?
Okay, I want you to use your own example. I hope you're not next to your wife, but use an example.
Myself, Stanley Wakiaga, is cohabiting with Jen, and Jen is not aware that I'm also cohabiting with Esther, and I'm also cohabiting with Eunice. And in all these circumstances, we have properties together. Each of them, there is some property we have together. We have children together, and each of them believe that I'm their husband. Then at the point of death, now all these women come, each of them that have been living with this guy for the past 13 years, another one also 13 years, another one also 13 years, and all of them have met the requirements of being referred to as a cohabitee. So at this point, does this marriage, this cohabitation turn into a polygamous marriage, or what really happens?
Yes, so in that instance,
yes.
In that instance, if you didn't have any existing monogamous marriage, then all of them are your wives. All of them are your wives, and that is deemed as a polygamous marriage. All of them are your wives for purposes of that instance. But the moment you already have the wife that you already married, you can't cohabit. So in the instance where they can all show, okay, in the instance where they can all show that there is evidence that you live with all of them, and for instance, live alone even in the example that you've given, even in the village right now, you could go to the village and find a man living together with 2 women, that he has not married. None of them is married legally under any customary law. Those two women are calling themselves the wife to this guy. They're living together for years. Both of them have kids for this guy. They're doing everything together, but there's no evidence of marriage anywhere, whether customary, all that. So all of those are cohabitations. But in that context, they're cohabiting under the customary law. And therefore, if this man dies, then they will be deemed to be this person's wives within the customary context of polygamy. And this you've seen a lot of times people just cohabit. Somebody will have 3 wives in the village and none of them is married actually. They just live together and do everything they want to do together. So yes, that is the context.
Thank you.
All right, any other last question? So I want you guys to have this point very clear in terms of who are the beneficiaries to the estate of the deceased person. The beneficiaries are wives, former wives, children that were taken in by the deceased person, and the relatives. Are you together? That is that. So today I want to talk about grants. I want us to talk about grants, grants of representation, and all that. Okay. So let me bring up my screen. So we've talked about both, that is intestacy and testacy, and today I want us to get into grants. Can you see my screen?
No.
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 Okay, so I don't know why you can't see my screen, but let's try again. Okay, it's supposed to be up now. I think you can see it now.
Yes.
Okay, so grants of representation, guys. So you need to understand what a grant is. So the first thing you need to understand is the procedure of getting a grant. What is the procedure of getting a grant? The procedure of getting a grant. That is where we start from. What is the procedure of getting a grant? Somebody? What is the procedure of getting a grant? That is the first thing you understand, and then you can go to the various types of grants and what happens and what happens and what happens. Okay? Yes? Somebody, what is the procedure of getting a grant? Guys, we've discussed this in the 7th classes that we've done. The 7 classes we've done. Okay, my goodness. Guys, nobody knows how to get grants. Yes, Tianga, we start with you. One.
You first make an application for the relevant grant, and then the registrar will verify the application. And then this application is placed before the judge for propoundment of a will if there's a will, and also confirmation of the application. The judge will be confirming the application. And then the judge will order for gazettement. After the order for gazettement is made, the notice will be sent to the printers for publishing, for gazettement.
Which printers?
For to the government printers. To the government printers for publishing, which will run for 30 days. After which, if there is no contention, the temporary grant will be issued. And then after the temporary grant is issued, they will go into preparation of the distribution of the estate. If at all the person was intestate, you prepare the schedule for the distribution. And then after that, after 6 months, this will be within the period of 6 months. Then after 6 months, you make an application for confirmation of the grant, attaching the schedule, if at all you do have a schedule. And then there'll be confirmation of the grant, and then distribution and administration of the estates, after which the personal representative is also supposed to come back to the court and report and make an account for the distribution, the administration. Yeah.
All right. That is amazing summary. That's a good summary of what we have in as far as application for grants are concerned. So guys, a grant is a court order directing on how the estate is supposed to be distributed. That court order that will direct on how the estate is supposed to be distributed is what you're calling a grant of representation. That is the grant of representation. Are you together? That is the grant of representation. Now, there are various types of grants. There are various types of grants that you're going to apply for depending on the circumstance. So these are the types of grants that you need to understand. Okay? Now, let us come here so that we are all clear on section 53. All right, you can see my screen.
Yes.
All right, so we have two categories, two broad categories. The first category is the main grants, that is the main grants of representation. The second category is the limited grants. Okay, now let us go back into the civil a little bit. Let us go back into civil a little bit. Now you understand that in civil we have the rulings and then we have the judgments. Okay, now the judgments will come from pleadings. Okay, will come from pleadings. Are you together? So that the main outcome of the case is the judgment. But within the proceedings, you can get a ruling or a temporary order through a ruling. Okay. Now, when it comes to grants, now the main grant that distributes the entire estate is what you're calling the main grant. That is the main grant. But in between, as we wait for the main grant, we can go to court to get what you're calling a limited grant. Now, a limited grant is a temporary grant that is issued for a specific purpose for a given time to allow you as the person applying for that grant to do something in the estate of the deceased person. Okay, limited grant. So limited grants coexist within the time that application has been made to the time that the grant is issued. Are you together? So when the main grant is issued, when you have the main grant, you can't apply for limited grant because whatever you can do with the main grant can be done by, whatever you want to do with the limited grant can be done by the main grant. Are we together?
Yes.
All right. So
Yes,
we have
yes.
the main grants and we have the limited grants. The main grants and the limited grants. So what are the main grants that we have? Now we have three categories of main grants. We have three categories of main grants. Now remember, we have tested succession and then we have intested succession. So where there's a will, there are two instances. The will has appointed the executor. The will has appointed the executor, and number two, the will has not appointed the executor. Are you together? So somebody read for us 53. Somebody read for us 53.
If I may,
Mhm.
forms of grant, a court may A, whereas deceased person is proved whether by production of a will or an authenticated copy thereof, or by oral evidence of its contents, to have left a valid will, grant in place of all property to which such will applies, either 1. Probate of the will to one or more of the executors named therein, or 2. If there is no proving executor, letters of administration with the will annexed. And B, if and so far as there may be intestacy, letters of administration in respect of the intestate estate.
All right. Thank you very much. Thank you very much. Are you together?
Yes, Mwalimu.
All right. So now let us dive, go deep into this grant so that you understand, because you will be told, please advise what type of grant this person will be, what documents this person will be lodging in court, what documents is this person going to lodge in court. Okay, what documents this person is going to be lodging in court. So first, where there is a will, there are two things. The will, as mentioned, the executor. The executor is the person who will administer the will. So where the will, as mentioned, the executor, then we have the grant of probate. Grant of probate, where the executor as mentioned, where the executor has been mentioned in the will, the grant of probate. Okay. Now, where the executor is not mentioned in the will is there, yes, but the executor has not been mentioned in that will, then we have to look for that executor, and therefore we have to go and apply for letters of administration. Okay, but in this instance, we have a will that is already written. So we are going to have letters of administration with written will annexed. Okay, letters of administration with written will annexed. Are you together? So grants of letters of administration with written will annexed. That is where there's a will, but the will has not appointed the executor. So we are going to look for the executor by having somebody apply for administration. So the person will be called an administrator because he will be administering the wishes of the annexed will, where the will did not mention the executor. Okay, so those are the two main grants where there's a will, that is grant of probate and grants of letters of administration with written will annexed. Now, where there is no will at all, then we are going to have grant of letters of administration intestate. Are you together?
Yes, you're together. Yes, sir.
Any question? Yes, Owino?
Yes, I wanted to ask, now that we've said that this is grant of letters of administration with written will annexed, is there one for oral wills?
Yes.
Where a person leaves out an oral will?
Yes. So if there's an oral will, it's the same grant of probate for an oral will. The same grant of probate because there's a will. So anytime there's a will, then of course you have that. There's a special form for grant of probate of oral wills. So oral wills has their own, but it's still grant of probate for oral wills. With oral wills, but of course you can't annex an oral will. So that is the rule.
Okay, thank you.
Yeah, so we have grant of probate special form for grant of probate of oral wills. Any other question? All right, no question. So those are the main grants. So guys, if you see in a question, somebody died testate, then it is either we have grant of probate, that is where there's a will and the will has appointed who is going to execute, or grant of letters of administration with written will annexed. That is where there's a will, but the will has not appointed an executor, or grant of probate for oral wills. That is where there's an oral will. Are we together? So that is what we are calling the main grants. Those are the main grants. So if they die intestate, no will at all, then we are going to have the grant of letters of administration intestate. Are you together?
Yes, we are together.
Okay. Now, the next thing is who can be given a grant? That is the next thing. Who can apply for the grant? That is the next thing that you must understand. Let us go back to my screen. Let us go back to my screen in terms of who can be given a grant. Who can be given a grant? Somebody read for us section 96. 96. Page 56, sorry.
Okay, let me read. Section 56, no grant to certain persons. Subsection 1, no grant of representation shall be made, A, to any person who is a minor or of unsound mind or bankrupt, or B, to more than 4 persons in respect of the same property. Subsection 2, no grant of letters of administration.
Proceed. We have lost you, or have you lost me?
We lost you.
Okay, somebody else read.
56. No grant to certain persons. 1. No grant of representation shall be made, A, to any person who is a minor or of unsound mind or bankrupt, or B, to more than 4 persons in respect of the same property. And 2, no grant of letters of administration with or without the will annexed shall be made to a body corporate other than the public trustee or a trust corporation.
Okay. Okay, perfect. That is the question of who can be given a grant, who can apply for the grant. Now, before you apply for a grant, there are a few things that you have to tick. There are a few things that you must tick. The first thing, you cannot be a minor. So minors cannot get a grant. Minors cannot get a grant. The second person is a bankrupt person. So bankruptcy, you can't get a grant if you're bankrupt, because getting a grant simply means you are dealing in the estate of the deceased person. You are dealing in the estate of the deceased person, which could be liquidated in terms of money. And therefore, if you're a bankrupt person, we don't trust you. We don't trust you with money because you couldn't even manage your own your own money. So a bankrupt person cannot be given a grant. Thirdly, is a person that is of unsound mind. If your mental capacity is in question, then we cannot give you a grant. You can't apply for a grant if you are of mental incapacity. So that is something that also you have to understand, that mental incapacity will affect your right to apply for the grant. Mental incapacity. That is very, very important. That is very, 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 very important. Okay. Now, the next thing is that when it comes to the number of people that can be given a grant, the maximum is 4. Okay. So listen. So in the instance where the will has mentioned 5 executors, in the instance where the will has been made and the will has mentioned 5 executors, then grant can only be given to 4, a maximum of 4, and not more than 4. Guys, give me 1 second. Let me confirm something. All right, Kamiri, you just came in right now. Can you zoom your kid? All right, so let's proceed to what I was saying, which is the question of capacity and the number of people that can be given grants. So if the person that has been appointed under the will become the executor. So if there are more than 5, we can't give all of them the grant. We can only give a maximum of 4. Okay. Now, if there's no executor that's appointed under the will, then we can only appoint up to 4 administrators. Up to 4 administrators. That is the number. So in terms of the number, the maximum is 4. Now, when it comes to both executors and administrators, the maximum is 4. Now, when it comes to administration, the maximum is still 4, but the minimum is 1 if there's no continuing trust, and 2 if there's a continuing trust. That is what I need to understand. So guys, where there's a continuing trust, okay, where there is a continuing trust, and then that means there's a beneficiary that is a minor. There's a beneficiary that is a minor. So if we have a minor beneficiary, then that means there's a continuing trust. It means their estate will be held for them in trust as they grow old until they get to the age of 18. And that is what we are calling a continuing trust. So in the instance where a grant has been made to one person and there's a continuing trust, then the court must appoint another person to become the trustee. Okay, that is the first one. The second one is if the grant was made to 2 administrators or 2 executors and one has died and there's a continuing trust, the court will halt the proceedings in terms of administration or execution until the second administrator or executor is appointed. So you need to appoint another person as a trustee. So in the instance where you have a child who is a beneficiary, then normally you are required that the next administrator or the extra administrator will be tasked with the obligation of holding whatever is left for the children in trust. Okay, so that is the minimum. The minimum is 1, maximum is 4. Where there's a continuing trust, minimum is 2, but maximum is still 4. Guys, are we together?
Yes, sir.
Any question? No question. No question. Okay? No question. So after that, let us go straight into section 6.6 to discuss now the priority of people that can make an application for grant. People that can make application for grant, that is the priority. So we've seen the types of grants, who can be given the grant, and in terms of numbers, what is the limitation? And then now we talk about the question of priority. Who should get it first and who should get it last? And how is that dynamic playing out? 66, somebody read for us 66. What is section 66 talking about in terms of the priority?
Preference to be given to certain persons to administer where deceased died intestate. When a deceased has died intestate, the court shall, save as otherwise expressly provided, have a final discretion as to the person or persons to whom a grant of letters of administration shall, in the best interests of all concerned, be made, but shall, without prejudice to that discretion, accept as a general guide the following order of preference. A. Surviving spouse or spouses with or without association of other beneficiaries. B. Other beneficiaries entitled on intestacy with priority according to their respective beneficial interests as provided in Part 5. Kindly scroll, Council.
Sorry.
Sorry. And then C, the public trustee, and D, creditors, provided that where there is partial intestacy, letters of administration in respect of the intestate estate shall be granted to any executor or executors who prove the will.
All right, that is perfect. That is perfect. So that is the priority. So first, guys, you need to understand a few things there. You need to learn. There's a lot of things to learn about that reading. So let us get through it one by one. So first, this is the priority of people that can apply for grant. Okay, surviving spouses, or with or without association of other beneficiary. That simply means that the surviving spouse may apply for the grant jointly with other beneficiaries. You've seen that if you're the child, if you're the widow, you can make an application for grant jointly with your son. So that's what it means. You can have it jointly with other beneficiaries if you so wish. And then the next one is other beneficiaries now. So we have other beneficiaries such as now the children, the stepchildren, or any person that is a beneficiary under part 4. That is beneficiaries in terms of intestacy, not beneficiaries in the will. No, beneficiaries in intestacy. That is the spouse, the children, stepchildren, as parents, step-parents, and all that. And then after that, we have the public trustee and the creditors. Okay, so you need to understand that that is the priority that is provided for in law. That is the priority provided for in law that governs the issuance of grants. That is the one that governs the issuance of grants. Are you together? Now, The next question that I want to ask is, and I don't know who I should ask this question. If you want to answer the question, put up your hand. Somebody? Yes, Abdisalan. So the question is, I hope you can still see my screen. Yes, you can. So in this instance, we have the widow. So the deceased person has been survived by the spouse, that is the widow, and two children. At the time of death, the deceased person owed, okay? The deceased person owed, let's say, owed you, Abdisalan, not Abdisalan, owed me some money. So the creditor to that estate, okay? When it comes to the time of applying for the grant, the creditor has applied for the grant. What is the next, or what are the options available to the spouse? Do you want me to repeat?
No, I don't think so. I think the option is the spouse will have to make an objection to the application for the grant because she's in a higher priority than a creditor, who is the last person.
Thank you. That is the first thing that I wanted to explain. So any person that is not in priority who makes an application for grant by skipping other people in priority will, of course, face the consequence of objections. Okay, so the surviving spouse will file their objections in the required form on the prescribed form, and then of course the ground of objection in that instance is that the creditor is not entitled to get the grant because they are not in priority or in the order provided for under section 6.6. Okay, that is the first question. The second question is the spouse has refused to apply for the grant. What is the remedies of the creditor? Yes, somebody else. What is the remedy of the creditor if the spouse has refused to apply for the grant? Kamiri John, the man from Kabete. Kamiri John? Zaweria?
The creditors will cite the spouse.
Yes, so you file your citation application in court, of course, asking the spouse to either apply for grant or renounce their right to apply. Okay, perfect. Now, that is what I wanted to understand. That is the priority, objections, and then citation. And then lastly is what you're calling Passover, or passing over. Passing over. Are you together? So in terms of passing over, that is also part of section 66. That is also part of section 66, which I want you to understand what Passover means. What is Passover? So in terms of Passover, what are we saying? We are saying that the court at any time may pass. Okay, the court may at any time pass anybody that is in priority. Okay, so normally you're supposed to make the grant to the spouse, children, trustee, creditors, but the court can skip the spouse and give that grant to the trustee, or skip the children and give it to the trustee. Okay, that is what we're calling the Passover. Of course, if you're a Christian, you know very well what happened in the book of Genesis. Was it Genesis? It says that Genesis or Exodus, when the angel of death was passing over the houses of the Israelites. So that is exactly what it is here. So the court has the duty and the power to pass over anybody that is in priority and give the grant to somebody else. Now, in the instance, for instance, let me give you an example where you don't get the grant. If you've been left as the widow, you've been left with 3 beneficiaries, 3 children, maybe young kids, okay? And you were drinking. Kazi ni kuamka, naamka quiver, unalala, ingine inaitwa aje, whichever name that is. You're just drinking all the time. You leave in the morning and you come back home at night drunk as a woman. Very, very, very bad. So if the court has evidence that you're a very irresponsible mother, you don't get the grant. You will never get the grant. In fact, for the court to give you the grant itself, the court must, because remember, Article 53 talks about the interest of the children, the best interest principle. So the court will never give you a grant if there's evidence, okay? And these are actual reasons why the court has denied people in the past, people in the past grants. There's a time I represented a client of mine who wanted a grant for the estate of the husband. Now the husband died and this lady moved on too fast, man. Too fast. Ladies, sometimes don't move on too fast. It's bad. Too fast. By the time you're applying for the grant, the lady was already having somebody, and the in-laws came and say this lady is very reckless, just bringing men. They want to squander the estate of our brother with this new man that he has found. So I was there, and since my client didn't disclose this fact to me, this fact wasn't disclosed to me. So when we went for the hearing of confirmation of grant, I was also shocked, like, huh? So I'm looking at my client like, huh? And then, of course, your guess is as good as mine. I was told, Jackton, you and your client, no grant for you. So we are not given the grant. And the reason why we are not given the grant is because the lady was portrayed as very, for lack of a better word, irresponsible in terms of maintaining the estate of the deceased person and taking care of the remaining children. She was portrayed as somebody who will get the grant and sell the entire estate and go gallivant with, the people that they have moved on with. So based on that reason alone, she wasn't given the grant. And but personally, I was paid. My fee must be paid. I don't care whether you get your grant. But that is the reason why she wasn't given the grant. Other instances are there are times that I've also seen in court where evidence has been brought, and this is for all gender, that the man is drinking too much alcohol. Chances are, if they're given the grant, they will drink that entire estate and the children will suffer. Or that the woman is drinking, or the woman is irresponsible, the woman is not, it is a flight risk. For instance, you don't have a single place of residence, you not get the grant, because we look at the interests of beneficiaries. So if there's evidence that you cannot be the best person to administer that estate, you will not get that grant. Okay, so the court must always look at that. The court will look at that. Second instance also, which is a common reason all the time, is the question where the beneficiaries cannot agree. If the beneficiaries cannot agree, they keep fighting. The mother and the kids are fighting all the time. Then the court will not give the grant to either of them. The court will pass them, and the court will give the public trustee, for instance. So the public trustee is the one that usually gets a lot of grants. More so in the instance where the beneficiaries cannot agree in terms of that estate. So the public trustee will be given the grant, and then they will administer that estate. Okay. So remember that in the instance where you're applying for a grant and you have adult children, they have to consent in writing that they've allowed you to apply for that grant yourself. So if they can't consent, and also when they're applying, you can't consent, the grant will not be given to the two of you, because that will conflict the estate, and you will end up interfering with innocent beneficiaries. Okay, so the takeout or the takeaway from that story is that don't move on too fast as a lady. Hata jifanye tu, hata unalia kidogo, fanya hata uko na huzuni, heartbroken. Don't move on the following day. Hey, no, our lives
Sorry.
matter.
Cancel.
Oh. Yes.
What exactly is too long? Like, she should mourn for how long? Did the court establish?
No, it's not about like this evidence that was brought in court at that time was the fact that this affair was existing even before the deceased person went to see God, you know, and this in-laws, you know, if you want to know whether you have good in-laws as a woman who is married, wait until their brother dies. That is when you'll know the kind of family that you got married into. Very, very crazy. So they came and said that this lady has been moving around with this guy. You know, my first expectation was for this lady to deny the fact that I don't know this guy. So the lady accepted on oath, accepted that she knows this guy. I'm like, huh? Yeah, that is how you throw your advocates under the bus. And then they went ahead to establish the fact that she had been moving around with this guy even before the death of the deceased person. And they produced receipts, you know, they produced receipts, evidence that she'd been with this guy. And I didn't know, you know, so you can imagine what was happening in my head. And I'm trying to secure my interest and the client's interest and trying to tell the court that, Your Honor, this is trial by ambush. We didn't have this evidence in good time. We can't use it. You know, the judge told me, hey, keep quiet, sit down. So I was just like, okay, whatever it is, man, this is not my case. So I just told myself, maybe it's the deceased person who is punishing the widow. And I told myself, as a God-fearing man who is serious about going to heaven, I will not intermeddle with the estate of anybody. Okay? So that is the thing. So at least, you know, also, but even from an African perspective, one thing you need to understand that these people are Africans. Unlike other countries like the UK death is like eating lunch. You know, death is like eating lunch. You die today and you're buried. In fact, they have burial managers, people that just do the burial. You know, they even hire mourners, come and mourn in your funeral. They don't care. You die today, you're buried tomorrow. That is all. Story done. But for an African society, you need to show some kind of sympathy, empathy with the estate. You don't need to act like you're waiting for this moment, you know, you're waiting for this moment. You know, in some African cultures, if the man was rich and the man has died, there's some expectation somewhere. Some people somewhere will be thinking that maybe you had a hand in the death of this person, so they'll be watching you. If you laugh, even if your neighbor came and told you something funny and you laughed, they will say you're laughing that this person has died. You see, Africans are very funny in terms of these things. So you'll be walking on a shell, but also you need to show, for purposes of these things, even judges are human beings. Judges are human beings. So if there's any conduct, if there's any misconduct on the part of the lady in terms of their actions, on how they treated the deceased person, and also remember, by the way, how you treated the deceased person when they were alive will also matter when you get the grant. You can't get the grant if you didn't treat the deceased person well. You can't get the grant. If there's evidence to that effect, the court will not give you a grant. You know, if you didn't live with the deceased person, you are living in Mombasa and they were living in Nairobi or Kitale, and there's evidence that you're denying the deceased person their conjugal rights, you will not get that grant. You could inherit, yes, as a beneficiary, but you'll never get the grant. You know, those are very, very petty reasons why the court will deny people grants. It's a very, very simple. So when it comes to grant, if you become a lawyer, I mean, if you become an advocate and you get a client that is doing administration, you need to prepare for the hearing. That is the hearing for confirmation of grant. You know, that hearing, they call everybody. All beneficiaries will come, appear before the judge. That is when you'll hear evidence that you've never heard as an advocate, and then you'll not even have a response. You'll be like, okay, Mungu, afanye vile utafanya, and then you go your way. So prepare your client for that confirmation. Every petty reasons can be a reason why your client does not get the grant. So at all times, also make sure that your client is behaving. Just behave. And also we have seen courts that have denied men, but most so this is a constant. I think out of 80% of men don't get grants for the estate of their deceased wives. 80% of them. There are a lot of reasons why courts don't trust men with the grants of their estate, the deceased person's estate, unless they were forthcoming and straightforward husbands and to those women. So there's a whole dynamic. The fact that that person was your wife doesn't mean you get the grant. Okay, you can't getting the grant is not easy. So it is what it is. So that's it. Who are Joanne?
Okay, Mwalimu, so if such a person had been appointed under a will, the court would not interfere?
No, the court will still interfere. If there's evidence, remember, the court has the power to give the grant to somebody else. In terms of confirmation of grant, section 71, the court can order that grant be confirmed in the name of somebody else. For instance, even if you're given the grant, remember when you apply for the grant, you get the temporary grant, okay? You get the temporary grant. Now, you could be having the temporary grant in your name, but when it comes to confirmation, things have changed and your conduct has changed. You will be denied the confirmation. You'll be told the grant is being confirmed now in the name of another person. Okay? Because now people will file for protest. That is when people start filing for protest. Maybe something can change. You are sick now. You are sick. Your mental status is gone. You are bankrupt as a person now. You can't get the grant if you're that. So the court has power even to throw away the executors in the instance where the executors have given reasons or there's evidence to show that giving that grant to the executor is not a good choice. Another example is intermeddling, where the executors have intermeddled or have squandered the estate of the deceased person. Okay, executors disown thoughts, so they will not get the grant. So any person is not immune. No person is immune from the court's discretion when it comes to giving out grants. Okay.
Yes, that's in order. Thank you.
Okay, sawa. Owino, and then Anyanzo.
Yes, well, I have a question that stems from a certain question that I was asked while I was in my village. So one of the villagers approached me as a counsel and asked me whether they could do succession in an instance where one of their relatives, one of the brothers, had gone missing. Like they just they are somewhere in Nairobi, but they can't be traced. So what happens in such an instance? We know that they are alive, but they can't just be traced. They are unreachable. So how do we go about succession?
Section 386 of the CPC, you have to do an inquest and you have the court to declare them dead. If somebody is missing, you can't until the court has declared them dead, until you have evidence of their death, you can't distribute their estate. Because number one, you have to, when you do that succession, Alphonse, where will you get the death certificate? You have to file it. Where will you get it? Death certificate must be there. So when somebody is missing and they can't be traced, or they're missing and they've been believed to have died, then Section 386 talk about inquest, and subsection 7 talks about in the instance where somebody has been missing, then the magistrate will decide on after how long they are supposed to be declared dead. So if you normally 7 years, so after 7 years you'll be declared dead. Okay, after 7 years without coming back, you'll be declared dead. So after that, then of course you will get the death certificate after they've been declared dead by the court. The court must declare them dead first. You can't just wake up and do an inquest. Maybe wanajificha. Where is your village? Are you from Siaya? No. So if this person is just hiding from their villagers, they're not there. They're just doing their life in Nairobi. Nairobi is a very hard place to live, so they're just finding peace in Nairobi. Maybe they're married somewhere. I know you come from the lake, so maybe they found a lady from the mountain, you know. Those men from the lake really love the mountain, so they're there enjoying their life, and wewe unasema wamepotea. Wajapotea ni wewe huwezi mpata. So yes, tell those guys that if they try, all of them will go to jail for stealing and for dealing in the estate of somebody else without consent. That is stealing, and committee or Odiaga is very open for such people. So no, they have to be declared dead by the court. If the court does not declare you dead, you are still alive, my friend, even if it is after 50 years. All right, Anyanzo?
Yes, Council. Now, allow me to just go back to the scenario that you shared about your client who had made an application for letters of grant of administration. In this case, the persons who were objecting to her, would it be competence as an administrator? Did they approach, would it mean that they approached the court by way of an objection?
No, protest.
Or by way of a protest?
You file affidavit of protest. Anytime somebody makes an application for confirmation, then if you are objecting to that confirmation, then you file an affidavit of protest to show why you are objecting to the confirmation. Okay, so you file an affidavit of protest, like we said in the last class. There could be a lot of reasons why you are protesting to the confirmation. There could be a lot of reasons. Are we together?
Yes, thank you.
Okay. All right, guys, so that is done. That is okay. So I want us to talk about the contents of the application. What are some of the things that you will have in the application? All the past papers that have been set until 2021 June, the question has always been the contents of the application for grants. What are the contents of that application? What will you put in that application for grant? What will you put in the application for grant? And this is provided for also under Rule 7 of the Probate and Administration Rule. So guys, understand this, because this, guys, this will form the basis of objections. These are the grounds of objections or the basis of objections, because when I make an application for a grant, I will include all the information under 2. Okay, I will include all the information under 2. If you are going to object, you are going to read my application and you're going to find the details from 2A to 2I. Okay, and then if you have a problem with either of them, you file the objections. So understand what goes into this petition for grants. Okay, now somebody read for us that.
So every application for a grant of representation shall be made in such form as may be prescribed, signed by the applicant, and witnessed in the prescribed manner. 2, an application shall include information as to A, the full names of the deceased, the date and place of his death, his last known place of residence, the relationship, if any, of the applicant to the deceased, whether or not the deceased left a valid will, the present addresses of any executors appointed by any such valid will. In cases of total or partial intestacy, the names and addresses of all surviving spouses, children, parents, brothers and sisters of the deceased, and of the children of any child of his or hers then deceased. A full inventory of all the assets and liabilities of the deceased, and such other matters as may be prescribed.
All right, thank you. So guys, this is what you will have in your petition for grants. This is what you will have in your petition for grants. Okay. Right. So full name of the deceased person, the date and place of the death, last known place of residence, the relationship between the applicant and the deceased. Who are you? Who are you? Okay. Who are you? So number one, full name of the deceased person. So if you feel like the name of the deceased person that has been listed there is not his name, you object. The date and place of his death. If there's a problem with this, you object. Is last known place of residence. Again, the relationship between, this is where now main serious objection starts here. Let me highlight that. Serious objections will start there. The relationship between the applicant and the deceased. So if you are going to say in that application that I am the wife, I am the child. Now, if they know that you are not the wife or the child, then we are going to object and say that you are not the child of the deceased person. You are not the wife of the deceased person. Okay? All right. Now, the next one is whether the deceased person left a valid will. This is also a question to be litigated on objections. You will be saying, yes, the deceased person left behind a valid will. If I read that and I know the deceased person did not leave a will, I will object. Okay? The present addresses of any executor appointed by any such valid will. So if you are the one who was appointed, you will say there. But if I know that you're not appointed, I will object. Okay? Now, in cases of total or partial intestacy, the names and addresses of all surviving spouses, children, parents, brothers, sisters, the deceased, sister of the deceased, and the children of, and of the children of any child of his own or has then deceased. A full inventory of assets and liabilities, and any matter as may be prescribed. Are you together? So this is what goes into the application. This is what goes into that application. This is what goes into the application. Are you together? So make sure you understand. Make sure you understand, because you will be told, please inform us or describe or list 5 details or 5 things that you will include in the document in A above. So if you know the document in A above is letters of probate or a petition for grant of probate, then you proceed and indicate there. So most of this information, they will actually, almost all this, whatever I'm highlighting right now, they'll be in the affidavit. This information will be contained in the affidavit. The petition does not contain a lot of things. I'm going to show you shortly. The petition will not contain a lot of things. Most of these things will be in the affidavit. Are you together? Any question, guys? Any question? Okay, Tiana, Jennifer?
Mwalimu, my question is on the hierarchy of those who can be given the grant. Does it matter if you're told to list them? Does it matter if you do, or if you lump the children together with other beneficiaries, or you have to separate them?
No. You provide who is there. So the reason why they're saying children and other beneficiaries, now if they're children, you say children only, and the spouses. Okay? If they are no children or no, spouses, that's when you go to the parents. If there are no parents, brothers, sisters, or any relatives. So remember the list of those who are entitled. So if they're children, then you'll not mention anyone else. So it is, you proceed as that. I don't know whether you get what I'm saying.
Yes, I am willing. Thank you.
Okay. Somebody else. Nobody else. So guys, let us try and see. When I joined the Kenya School of Law, long time ago, maybe you are still in nursery school, we were told that nobody will set for you a petition for letters of grant of probate. Nobody will ask you to draft this. And maybe you might have heard some of your lecturers saying that. And then the year that exams were done, they actually set 2 of them. You know, they set 2 of them. The same year that you were told that, oh, no, hakuna mtu atakuuliza draft hizi vitu. And then boom, that year they set 2. So it means you can't escape. If they set the 2 of them, you can't escape. The questions are only 6 and you can only leave 1. So you can't escape drafting that question. You'll have to draft anything. So what am I saying in short? That when it comes to CLE will set anything and everything. Okay, CLE will set anything and everything. Now these are standard forms. These forms are in the rules, but I'll give you a sample. Petition for grants is a very simple matter. Petition for grants of letters of administration intestate. It will be the same thing. It will be the same thing. So this is Form 80. Can you see it?
Yes, we can.
Okay. So Republic of Kenya in the High Court at Eldoret, succession course number that, because remember this is succession, so succession course number that of that in the matter of the estate of the deceased person, in name, at least the name of the deceased person there. Petition for letters of administration intestate. That is why you don't write Form 80, Form R7. No, just write exactly what you can see on your screen. Exactly what you can see on your screen. Are you together? All right. So the same thing I've said. So I, that person of PO Box that, hereby petition the Honorable Court for letters of grant of administration intestate of the estate of the above named deceased person who died, okay, who died on that date, okay, and say as follows. These are the standard words that are there in the form. You just download it, fill that the deceased person died intestate. So you have to tell us how the deceased person died, intestate or tested, and the last place of domicile is last place of domicile was that place that you present this petition in your capacity as the widow. You have to give that capacity. I've said you have to show the capacity. Under what locus are you applying for the grant? So you can't just wake up and apply for grant. Okay. Guys, are we moving together?
Yes.
Yes, sir.
All right. So that is the capacity that every person having equal right to grant as consented. This is a question of consent, that other beneficiaries that have the right to apply have given your consent that you apply. Okay. And then the deceased person left no debts. For instance, there's no liabilities. And then this is the word. That is the petition that I will faithfully administer the estate according to the law, or the estate by law devolves upon the or vest in. So you don't have to go through all this. These are things that we say in practice so that we can be paid. You know, legalese is only sweet in the mouth of the client. You only say that in the mouth of the client. Okay. It is only sweet for the client. It is very, very sour for the judge and for the examiner. So don't say a lot of legalese. Just say that I will faithfully administer the estate according to the law. Full stop. Okay. So signed by the above named person, and then drawn and filed by to be served upon. Okay. So this is the petition. This is the petition. That is all. You're done with the petition. You're done with the petition. This is the petition. That is petition for letters of grant of administration intestate. Okay. Now after this, you come and do your affidavit, which is usually Form 5 affidavit. The same thing, same caption. In the estate of that person, affidavit in support of the petition for letters of grant, letters of administration intestate. I, that person, do hereby make oath and state as follows. So you give us the details that I've shown you in the act, that the full name of the deceased person is that person, and that you are the petitioner named in the petition dated that, that the deceased person died intestate on that date at that place. The deceased person was at the date of his death a citizen of Kenya, and last known place of residence was that. The deceased person left the following beneficiaries. Okay, Gladys, Eunice, Martin, all that. So you tell us who they are. The wife, the widow, son, daughter. Okay, that we are related to the deceased the deceased person by virtue of being his widow and son respectively. That is, if you are both applying, both the son and the widow are applying at the same time. That the following is the full inventory of his assets. So give us the inventory of the assets. What are the assets? Okay, what are the assets? So pieces of lands, Eldoret municipality, that, and then motor vehicles, and then bank account. Okay, so give us all the list of assets, and then you come and give us the list of liabilities. So in terms of liabilities, if the liabilities are not there, you just tell us nil, that there is no liability. Okay, and then that the deceased person, the petitioner will produce copies of documents when so required. That is not a requirement. And then you say that the facts, whatever you stated herein, is true to the best of your knowledge. That the normal things that you say in your affidavit, and then you sign that affidavit, and then you're done. And then this is the other affidavit, that is affidavit of justification of proposed administrator. Now, let me explain. So when you're told to prepare this, you only prepare the petition, the short petition, this one, together with the affidavit in support. Other documents are regarded as accompanying documents. For instance, affidavit of means is regarded as a accompanying document. Affidavit of justification of the proposed surety is also accompanying documents. So you don't need them. Death certificate, those are accompanying documents. Don't prepare them. So you only prepare the petition and the affidavit. Okay. Now all these forms are in the rules. Now another thing I need to mention again is that you don't need to write it the way you're seeing it there. You can use your words, so long as you have the details that have been provided for in the rules. Okay. So the most important thing, guys, let's go back to the screen. Let's go back to the act so that I can let you guys be. You see this information? All this information that I've just highlighted. This is all you need. So if you know them, just put them in that application. It doesn't matter how you put them and which order. It doesn't matter, so long as they're all there. That is the hack of drafting that. So long as you have the caption, which is Republic of Kenya in the High Court, if there is an estate going to the High Court or in the Magistrate Court, in the matter of the estate of person XYZ, deceased person, then you give us the name of the petition, which is the petition for letters of probate, meaning petition for grant of probate, or petition for letters of administration intested. And then you give us the introduction, and then you give us this information. Okay, the full name of the deceased person, Sorry, give me 1 second. All right, full name of the deceased person, date and place of death, last known place of residence, all that. So you can put them either way. You can have one at the first paragraph, one, there's no order. So long as your petition and your affidavit will have that information. Whatever is in your petition will also be in your affidavit. Are we together, guys? I don't know whether that is making sense. It will not make sense right now, but it will make sense finally. Guys, are we together?
Yeah.
Yes, we are together.
Yes, sir. Yes, Kabisa.
Any question? Tianga?
It's just a slight question on the sign off for the petition. I saw, I don't know if it was about talking about a deponent. So we are referring to them as deponents, like in affidavits, Ama.
This is an affidavit. There is accompanying affidavit. This is a supporting affidavit. You have to, every petition must have an affidavit.
Ah, okay.
Let me go back to my screen again. So if you can see the screen, this here is the petition. This is the petition. Okay, this is the petition. Signed. Deponent doesn't mean is being sworn. Deponent simply means somebody who is signing. But this is the petition. These few paragraphs, 5 paragraphs, and then you go to the affidavit. This is the petition, and then this is the affidavit. Okay, this is the affidavit. So in terms of affidavit, you just prepare the affidavit. You swear the oath one by one, until the last bit, which is now sworn by the said person at that place at that time. So the affidavit is the one that must be sworn. Okay, the affidavit is the one that you have to swear. The petition itself, you can just sign. You find some crazy people in practice having them deponed, but no, you just sign it. It is not a requirement that they have to be commissioned. So only the affidavit will be commissioned before the commissioner works. Tuko sawa?
Sawa mwalimu, thank you.
And all other affidavits that we're going to have, like this one is affidavit of justification or proposed administrator. Are we together?
Yes, mwalimu.
Any other question? All right, guys. So that is the question to do with grants, the introduction to grants. So I want you to know how to prepare these grants, and then we can do the limited grants. So don't know exactly how best I can help, but I want you to go first through the grants, the things we've discussed, and then after that, you can come back and tell me if there's something, or if you guys are not sure about how to draft this thing, we can all draft it in class. Okay, we can draft it in class. Just one so that you can see how that is done. It is a very simple thing, by the way. So I want you to go through it, try and see it yourself. And then after that, we can revise it and see the ones that have been set in the past papers. And then we shall discuss the question of limited grants, and confirmation of grants, as well as revocation of grants. So we don't have a lot of classes remaining. For probate, we just have maybe two classes. Okay, 2 classes, so that the rest we will handle. The rest we will handle as we go in the past papers. So there's nothing much left on probate. After grants, we just done, so that we can start now religiously past papers, and then you understand. So probate, guys, there's no hurry, there's no pressure, there's nothing. Just understand up to where we are or further from where we are, but make sure you're not behind. Any question before we can adjourn so that you can take a rest? It's been a long week for everybody. Are we together?
Yes.
Amunyu?
Thank you. Just trying to understand section 53, where it says that if there is a valid will, the court can grant probate to the named executor or letters of administration with the will if there are no executors. So can there be a will with no executor in the will, or am I getting
No.
it? Sorry. Sorry, I can't hear your reaction.
Guys, can you hear? Or is my Wi-Fi?
You're audible now.
I'm saying, Kamunyu, can you repeat the last part? Paris and Kamunyu, repeat the last part of the question you said. Can there be a will?
With no named executor.
Are you in his class, Kamunyu?
I might have, when you asked that question, then clearly I missed something. Apologize for that.
What are the types of grants that we have? Let's start there. Types of grants that we have. Main grants.
Yeah. So one, where there is a will, where there's a valid will, you will get the probate, and then in an intestacy case, then you get letters of administration.
How many types of grants did I say we have? Kamunyu and Dongi.
Might have missed that.
All right, Paris Muigai. What is your question? You said you had the same question as Kamunyu. Oh, okay. Yes, sorry. We are going to do asset accounts. Yes, we are going to do asset accounts. Asset accounts is just 30 minutes work. We shall do asset accounts. Don't worry about that. I will handle it personally myself. For myself personally. A lot of repetition there. But anyway, yes, we are going to do asset accounts. So somebody answer Kamunyu Ndungi on the types of grants that we have. Yes. Yes, to Joan.
We have a grant of probate. We have a grant of letters of administration with the will annexed and grant of letters of administration.
Give us the instances giving rise to those.
For a grant of probate, it is whereby now there is a will, a valid will. And then now for a grant of probate, For a grant of letters of administration with a will annexed is whereby
Start.
Okay, for a grant of probate, it is whereby now there is a valid will that has been left. For a grant of letters of administration with a will annexed is whereby now there is a will, but there is no named executor in the will.
So what is the difference? What is the difference between that and the first one you said? What is the grant of probate?
In the second one, there is a will, but there is no named executor in the will. So you are making an application.
In the first one?
In the first one, there is a will. Now you are making an application for the court to propound the will.
Hey, John, what are you saying? You are not giving me the difference of what I'm looking for, because you're confusing yourself also as well, and you're confusing others. What is the difference between the first one and the second one? Because you said in both instances there's a will. What is the difference, John?
The difference is that in the second one, there is no named executor. There is a will, but there are no executors in the will.
Start from the first one. Start from the first one.
Grant of probate is whereby there is a will, and in the will there are named executors.
That is exactly what you're not saying. Why are you not saying it? And why did you not say it in the first instance?
Okay, so in the second one, it's just as I've said, there is a will, but there is no named executors in the will. And then now in the third one, it is whereby there is no will, and now the application is being made for the court to appoint administrators to administrate the estate of the deceased person.
All right. Kamunyu Ndungi, are you answered?
Yes, I actually reiterated that. I was just curious that can someone write a will?
Are you answered, Kamunyu Ndungi? Are you answered?
I am very much answered. I just wanted to understand in practice, like someone will write a will.
Nothing like practice.
And have no executor. That's the thing.
It happens all the time. Close to 8, most of it all the time. Most wills don't have executors. For your information, most wills don't have executors. Most people will write wills, but they're not sure who will become the executors, so we don't include that. A lot of wills don't have executors. So just so you know, not all wills will have executors. A lot of wills don't have executors, so don't expect to see executors all the time. So yes, you can make a will and that will has nobody as the executor. Okay?
Wow, that's
yes,
serious.
it's possible. And it does not affect the validity of the will. The will is still very valid.
That's all needed to understand. Thanks.
All right, so guys, that is it for now. I will let you guys go rest, and we can proceed from the next Friday when you complete grant, and then we can start on limited grants. Please try drafting, try revising on the things you have